Welcome to MOJIS YouTube class. In today's video, we will dive into the complex yet crucial topic of writ jurisdiction. Understanding this concept is essential for your success in the exams. So, let's get started. Before we delve into the intricacies of writ jurisdiction, let's begin with some basic definitions. Writ jurisdiction refers to the power of higher court to issue writs, which are extraordinary legal remedies. These writs are designed to protect fundamental rights and ensure justice when other legal remedies are not sufficient. So remember that the writs are designed to protect the fundamental rights and ensure justice when other legal remedies are not sufficient. So this is the basic thing that we have to know about writ. You have to know what is writ. What is writ? They are a judicial feature. They are designed to protect fundamental rights and ensure justice when other legal remedies, that may be any act or something, other acts and legal remedies are there, if they are not sufficient for dealing with a case, then comes the writ jurisdiction, and the writ jurisdiction refers to the power of higher courts to issue writ. The higher courts have the power to issue writs. So which are the higher courts? High Court and Supreme Court. So they can issue writs to protect fundamental rights and ensure justice. Not only for protecting fundamental rights, also for ensuring justice. So ensuring justice means obviously protecting fundamental rights. So for protecting fundamental rights, the writ jurisdiction comes under. Okay, here there are 5 types of writs in India. That is the first one, habeas corpus, mandamus, prohibition, certiorari and quo warranto. Remember this 5 things: habeas corpus, mandamus, prohibition, certiorari and quo warranto. Now let's explore the 5 types of writs that fall under writ jurisdiction. The first type is habeas corpus, which literally means produce the body. It is a writ that ensures an individual's right to personal liberty. When a person is unlawfully detained or imprisoned, habeas corpus can be invoked to challenge the legality of the detention. It directs the detaining authority, that may be anyone, a public authority or a private person, a police, and etc., anyone. The court will direct this authority to produce the detained person before the court and justifies the grounds for their detention. This is exactly about the habeas corpus, that is, which literally means produce the body, and it ensures what? The individual's right to personal liberty. When a person is unlawfully detained, remember that unlawfully detained by someone, any authority, that may be police or government authority or a private person, even their parents, anyone can be that authority. So the court will direct them, that particular person or that authority, to produce the detained person before the court, and also they have to justify the grounds of the detention, why they detained the person. They have to justify the reason before the court. This is all about habeas corpus. Now I will just tell you an example of habeas corpus. See, for example, let's consider the case of Mr. X, who has been detained by the police without any proper legal justification. So the police is detaining Mr. X without any proper legal justification, and Mr. X's family can approach the court and file a habeas corpus petition seeking his release. And the court will then examine the circumstances of his detention and determine if it is lawful or not. So this is what an example of a habeas corpus. So Mr. X is detained by the police, and if there is no legal jurisdiction on the detention of this person, then his family, the Mr. X family, can approach the court, and the court will examine the circumstances of his detention and determine if it is lawful. And also there are some exceptions in it. We will be dealing with that while studying fundamental rights. There will be Article 20 and 21 are some exceptions to this case. So we will study that later. And here just remember habeas corpus. And if you have any doubt, just watch the video of fundamental rights that we are uploaded. Then moving on to the second type of writ, we have mandamus, which means command. Mandamus is a writ issued by a higher court to a lower court. Issued by a higher court to lower court or a tribunal or a public authority. This writ compels them to perform their official duties, which means this writ is issued by a higher court to a lower court or any other authority subordinate to the higher court to perform their official duty. This writ compels them to perform their official duties. It is used when there is a clear legal right but the consent authority fails to fulfill its duty. Maybe that may be a lower court or any authority. When they fail to perform their duty, the higher court will issue this writ, that is mandamus. They just command, as per the meaning, they command the lower body or a tribunal or a court or any authority to perform their official duty. This is mandamus, and let's go to an example of mandamus. Let's say a citizen named Mr. Y has applied for a government job and has fulfilled all the necessary requirements. However, the consent authority is deliberately delaying the appointment without any valid reason, even though he is eligible and he fulfilled all the requirements, and this authority is delaying his appointment. So there is no valid reason why they are delaying his appointment. In such a scenario, Mr. Y can approach the court and file a mandamus petition requesting the court to direct the authority to fulfill its duty and issue the appointment letter. So this is an example of mandamus. Here what happens, that authority is subordinate to the higher court. So the court issues a writ to that authority because they are not performing their official duties. So here the writ compels them to perform their official duty. So Mr. Y can get his appointment letter because there is no valid reason why they are delaying their appointment. If there is something, some issues with appointment, they have to justify what is the issue, why they are delaying that. If there is no valid reason, they must give the appointment letter to Mr. Y. The third type of writ is prohibition. It is a writ issued by higher court to a lower court or a quasi-judicial body or any authority to prevent them from exceeding their jurisdiction or acting beyond the scope of their authority. So there must be a jurisdiction for every authority. If, for example, if there is a high court of Madras or the High Court of Tamil Nadu, they have certain jurisdiction. This High Court is for the UT of Pondicherry and Tamil Nadu. And if they perform outside, if they investigate a case outside their jurisdiction, then comes the higher court, that is the Supreme Court will invoke this writ. They will invoke the writ jurisdiction and prevent them from exceeding their jurisdiction. Okay, then just look into an example. Okay, let's assume a lower court is hearing a case that falls outside its jurisdiction. The aggrieved party can approach the higher court and file a petition for prohibition, seeking to stop the lower court from continuing with the proceedings. The higher court will examine the jurisdictional issue and, if necessary, issue the prohibition writ, restraining the lower court from proceeding further. Okay, this is what happens in prohibition writ. Next we have certiorari, which means to be informed. Certiorari is a writ issued by a higher court to review the decision of a lower court, tribunal or any other authority. That means to review the decision of a lower court, tribunal or any other authority. It is invoked when there is an error of law or jurisdiction, or when the decision is in violation of principle of natural justice. So when there is an error of law, the higher court will issue a writ of certiorari to the lower court or any other authority. Okay, then see the example of certiorari. Suppose a lower court has passed a judgment in a criminal case, but there are allegations of the court misinterpreting a vital legal provision which result in an unjust decision. The aggrieved party can file a petition of certiorari requesting the higher court to review the lower court's decision. If the higher court finds merit in the petition, it may issue the certiorari writ and examine the legality of the court's decision. They will examine the decision of the lower court's judgment if the aggrieved person approached the higher court if there is any misinterpretation. Lastly, we have quo warranto, which means by what authority. Quo warranto is a writ issued to inquire into the legality of a person holding a public office and to determine if they have the authority or qualification required for that office. It's just to inquire the legality of a person holding a public office. That means a person is holding a public office, that may be in government officer. You can just, people can, any aggrieved person can approach the court, determine to inquire the legality of the person, if this person have adequate qualification, because every position in a government office or a public office must have certain qualification and requirements, and the person who's sitting in that position should possess that qualification, right? So we can encourage that by approaching the higher courts to issue the writ of quo warranto. Okay, just look into an example. Let's consider a situation where an individual, Mr. said, is holding in public office without fulfilling the eligibility criteria or without the necessary qualification. Any concerned citizen can file a quo warranto petition in the court questioning Mr. Set's authority to hold the office. If for just a small example is there, if that position must the person holding in that position must he should have a graduation, but in this case, if what Mr. said don't have a graduation and he came to that position through some other way, then you can approach the court to inquire the legality of that appointment, and the court will examine the qualification and eligibility criteria and determine if Mr. Set is eligible to continue holding the position. If it is he is not eligible, then the court will cut down his position and he will not be able to continue his position in that office. Okay, and this is all about the writ of quo warranto. And there you have it. We have explored the 5 types of writs that come under writ jurisdiction with real life examples to help you understand their application. Remember, having a clear understanding of writ jurisdiction is crucial for your UPSC preparation. If you have any doubts, please comment in the comment section below. And that's all about the class. Stay tuned for more informative videos to boost your knowledge. Good luck with your studies. Okay, bye. Then see you in the next video.